Hi everyone, it's Paul Tilley and welcome to LW 1230. Today we're looking at Unit 6, Property Law and Intellectual Property. This particular unit will be broken into three distinct sections. The first section we'll be dealing with is property law. And property law deals with things that we refer to as real property, which are tangible real estate items. Part 2, we'll be looking at personal property, that is, things that aren't necessarily real estate, but other items that would fall in the stuff that people own. In the third section, we'll look at intellectual property law, which relates to intangible items that people create and use that have business benefit. In this particular unit, we're going to look at several items, so we'll look at the unit as a whole here. From an objectives point of view, we're going to understand the definition of property law. Then we're going to explain real, personal, and intellectual property, the three basic types that I just described. We're going to explain ownership rights of real property. And we're going to understand the rights and obligations under commercial leases, which are related to property. We're going to distinguish between the different types of what we call bailment of personal property. And we're going to explain the importance of the intellectual categories of copyright, trademark, patents, industrial design, and trade secrets in carrying on a business. This is covered in Chapter 9, Property Law, Intellectual Property Law, in your textbook. So property law is really a broad field of law that includes a range of legal rights and duties in the areas of real property, which is real estate related property, stuff that's registered, and personal property. An interest in property determines whether an individual or organization owns the item and whether they have the right to the possession of the item, and if they have the right to transfer the interest in the item to someone else, or if they have the right to stop someone else from using the item or occupying the space. Property law can be divided into two basic sections: owned by government or owned by people. From an owned by government point of view, what we're talking about there is public property. This is the property that you and I can access because it's part of the public access. The streets, the sidewalks, crown land, these sorts of things are stuff that everybody can use. It's owned by the government, the state, the town, the municipality, the city, the province, these sorts of things. The second aspect is private property. When we think about private property, we're talking about things that are owned by individuals or business, that those individuals or those businesses can control the use of the property. They can exclude people from it. They can include people into it. They basically have the right to do what they want with the property. When we operate a business, it always involves some issue of property rights. So examples of this would include legal right of ownership over property, or right to negotiate a royalty from the property, or the fact that the property may pose some risk to others that the owner would be obliged to minimize. So let's begin at the beginning by looking at Part 1. Part 1 is real property law. Real property law is usually referred to as real estate and generally defined as land and buildings, including the fixtures in the buildings. Fixtures are items considered permanently attached to the buildings or land, such as fences, in-ground pools, central air conditioning units, and so on. The ability to make laws for the purchase, sale, and use of real estate is within the powers of provinces and territories. The first thing we want to look at in real property law is this issue of real property. And real property is real estate. And the rights that we have with real estate is we can buy it, we can sell it, and we can use it as we wish. And the powers that we have, or the laws surrounding all that, is normally of provincial or territorial jurisdiction. So in Canada, all land that's owned by government or under the control of the government that's not privately held would be considered as Crown land. The Crown is really government. We use the word Crown because it relates to the fact that we're a constitutional monarchy. So you can go, for example, and request Crown land. Government then will give you a right to it. They will lease it to you or potentially sell it to you for private ownership. Title or ownership of the land is then shown as belonging to the individual, along with the rights that come with holding the title to that land. This is known as something we call fee simple ownership. It includes the right to buy, to sell, to use the land, the security, to borrow money, to occupy it, to lease it, or pass it on to another person. So how about the mechanics? How do you record the ownership interests in real property? Well, the names of all landowners in Canada are recorded under a registration system maintained by each province. So you can actually, in Newfoundland and Labrador, you can take a look at this on the digital government page, which I've linked in the slides. So registration of interest in land provides a public record of who owns what. Newfoundland and Labrador has a computer-based registration system that allows electronic registration of documents, reflects interest in land. It's called the Companies and Deeds Online. The registration system records the documents that have been registered that affect land under the provincial system. Although that Companies and Deeds Online doesn't confirm ownership, it does provide who is the registered person on it. So purchasers are required to check the validity of the seller's authority to sell the land by searching the government files. So this is normally what lawyers do when there is a purchase and sale agreement, is that they have to go through the deeds in order to ensure that the land is indeed owned by who it says it is. In terms of taxes, land ownership gives rise to certain taxation obligations at the provincial and municipal level of government. At the time of purchasing real property, a land tax based on a percentage of the purchase price or assessed value of the property may be charged by the provincial and municipal governments. HST and capital gains tax may also apply to the sale of commercial real estate. So the transfer of commercial building will be subject to the harmonized sales tax, along with any capital gains, the difference between what was purchased for and what it's being sold for, that may arise from the sale of certain real estate. So in Newfoundland, for example, HST at 15% generally applies where a builder sells a newly constructed or substantially renovated house. That's not the case with regards to a resale house. There's no HST on that. In the case of the sale of property, an individual or company who experiences a capital gain, which is a profits, difference between what they bought it for and what they sold it for, on the sale will have to pay tax on it at the point unless the property is subject to the primary residence exemption. So what this means is if this is a business property that you're selling, you will have to pay capital gains tax on it. So for example, if you bought it for $100,000, you sell it for $300,000, that's a $200,000 capital gain, the difference between what you bought it for and what you sold for. That would be taxed at the tax rate on capital gains. Now, if you sold your primary residence, which is the home you live in, that is not subject to tax. So for example, if you own a home that you lived in, you sold it for $300,000, you bought it several years ago for $100,000, that $200,000 gain that you had would not be taxable. In the use of real property in Newfoundland and municipalities, provincial building code standards and municipal zoning bylaws will apply to determine, for example, the type of material used in the construction, the water and sewage system that needs to be installed, the heating systems, among other things. So a license from the provincial or municipal authority may be required for the intended use of the property, such as operating a restaurant or hotel. And that is the case in most towns in Newfoundland and Labrador, that if you're going to open some sort of facility, a restaurant, a hotel, it needs approval of the municipality, and there also may be provincial approvals for things like a restaurant or these sorts of things as well. Property rights and remedies. So whenever we own a piece of property, we have the right to sell it or to do as we want with it. However, if there is a mortgage on it, in other words, someone has loaned us money to buy that piece of property, the law needs to protect the mortgagor. They want to get their money back. So to make sure that happens, mortgages are registered with the property or against the property. And this allows them to alert any potential purchasers of the real property to the existence of a loan for which the land is being used as security. So the mortgage is registered against the property under the appropriate land registration system, for example, the Coda and Newfoundland. Registration also serves to protect the mortgagee's priority in the event a second mortgage is given against the land and registered on the title. And under the land registration system, the first party to register is the first person to be paid. In the event of a default, whenever we think about someone not paying their mortgage, for example, if we have a default in repayment, the mortgage agreement usually has some clause in it that contains an accelerated payment clause, which means that if you don't pay it, they can demand that you pay in full. Generally, a lender will give reasonable notice before demanding payment in full. As I say, most mortgage agreements contain a clause permitting the lender to sell the property in the event of a default. So, there's nothing to prevent the lender from taking the property and selling it. And they then will use the proceeds of that sale to pay off the mortgage. If there's an excess, meaning that the property gained more money than the mortgage was, then the person who owned the land, the mortgagor, would get the difference. And if there was a shortfall, then the mortgage company has the right to sue the mortgagor for the difference. Sometimes, too, there's a judicial sale where, for example, it goes to court, the judge ordered the property sold. Same sort of thing would happen there, that when it's sold, the monies owed would go to the mortgagor, and any that would be left over would go to the mortgagee. And in the event that there was a shortfall, they could sue the mortgagee for the difference. So now we've looked at residential. We know that, okay, mortgages must be paid, mortgages are registered. What about a commercial situation? Well, the rules under commercial tenancy operate very differently than rules for residential tenancy. Each province has legislation that regulates many of the elements of the landlord-tenant relationship in commercial settings. So first and foremost would be lease provisions, for example. In a commercial leasing arrangement, the tenant has possession of the property while the landlord retains the ownership of the property. A lease is signed by both parties, setting the terms of the agreement, such as the length of the lease, the amount of rent, when it has to be paid, who's responsible for maintenance or repairs, any restrictions on how the tenant will use the property. And provided the tenant meets its obligations under the agreement during the term of the lease, the tenant is allowed exclusive possession, and the landlord may enter the premises only under special circumstances, basically with the approval of the tenant. There are different forms of leases depending on whether the property will be used for rental operations, warehousing, office space, or industrial manufacturing. Leases are usually referred to as fixed tenancy, which are for special periods of time, such as 1 year or 5 years, 3 years, or periodic tenancy, which is for an indeterminate period of time, so go on indefinitely. In a periodic tenancy arrangement, the lease continues until either the landlord or tenant provides notice of termination. Provincial legislation, and usually the lease itself, sets out the period of time required for proper notice. The timing and form of the notice indicated should be carefully followed for effective termination of an agreement. So let's look at some of the basic lease provisions. So there's generally 4 types of commercial leases. A net lease, which is when the tenant pays a fixed amount of rent, plus a percentage share based on the size of rented space of the landlord's expenses related to operations, maintenance, ownership of the property, and so on. We also have a lease under which, in addition to the payment made under the net lease, the tenant pays for structural repairs to the premises as well. So it's an additional add-on. The third type of arrangement is something called a gross lease, and that's in which the tenant pays a fixed amount as rent on a regular basis. And the fourth element is a semi-gross lease, under which the landlord assumes responsibility for certain expenses under the base rent received from the tenant. So along with rent, GST, and sometimes provincial sales tax as well, is payable by the tenant based on the rental rate under the commercial lease. Both parties should really be aware of the provincial laws and the municipal bylaws that affect the use of the property. A tenant may have specific requirements concerning the use of the premises and the organization or setup of the business. The landlord may have certain obligations, such as noise restrictions imposed on them by the municipality or non-compliance clauses under the leases with the tenants of the property. Generally, commercial tenants are not allowed to withhold rent as a way of self-help to force the landlord to meet obligations under the lease. The lease should set out in clear language the rights and duties of both parties to the agreement in order to avoid a future misunderstanding and potential disputes that could end up in court. Along with the term of the lease and any right to renew the fixed tenancy once it's completed, the parties will want to consider who will be responsible for the repair and maintenance of the property while the terms of the lease are in place. Provincial law only requires landlords to maintain basic safety and property and warn of any dangers. Generally, unless the lease doesn't allow it, tenants have the right to sublet. The tenant may remain responsible for the obligations under the lease, and the subletting would be responsible to her or him. Likewise, if the business does not work out, the tenant will want to transfer the balance of the term under the lease by assigning it to another party with the intention that they will be responsible for the lease. So the next thing we need to look at is all other forms of personal property known simply as personal property. So we've looked at real estate. So basically everything that's not real estate would fall under the category of personal property. Personal property really takes two broad forms. The first broad form is tangible personal property, which is the focus of this particular section here. And the other form of personal property is intangible personal property, which is what we'll talk about in the third section. So if we look at a car, a toothbrush, your toothbrush, an oil painting, a transcript, a check, these are all examples of personal property. Okay? The check is a form of intangible personal property because what it does is it gives you a right to something, a right to receive money, a right for the bank to take money from your account and give to someone else, depending on who the check is for. So we need to be able to define and distinguish between personal property, real personal property, and intellectual property. Our focus, however, in this section is tangible personal property. And tangible personal property is everything that's not real property and is classified as something that you can touch. Our focus in this part is on tangible property, as I say, and these are chattels. The ability of a business to exercise rights over personal property, goods used in its operations, depends on whether the goods are owned by the organization or simply in its possession. So, again, we have to define or distinguish between having ownership of it and having possession of it. Basically, the concept of ownership of property is the right to possess and use it. However, there are circumstances in which the owner of goods may grant the right to possession to another party remaining the owner of the property, a rental car, for example. A situation such as this, where the key elements of ownership and possession of goods are split on a temporary basis for a specific purpose, is referred to as bailment, as usually set up in the form of a written contract. So a rental agreement for your rental car is something that is called in law as bailment. So bailment, the owner of the goods is known as the bailer, and the party in possession of the goods is known as the bailee. The bailee is under a duty of care of the goods while they have possession of them. The standard of care that must be maintained under the debt depends on the nature of the bailment. There are really two forms of bailment, often found in business setting. That is bailment for reward, including rental and consignment. So the rental car, the reward would be that you get the car and they get the money that you're paying for the rent of the car. And bailment could also refer to repairs and services. So you bring your car to the garage, for example. Both parties will have certain rights and duties under the legal relationship established by bailment. These are created through both contractual terms and conditions agreed on by the parties and the common law. The common law rules for bailment apply if there's no existing contract settled out in terms of the obligations, rights, and duties, or if the contract does not address a particular issue. So effectively, contract is the primary thing we look to whenever we think about rights and obligations. If the contract doesn't exist or if the contract is silent on something, then common law will be used to fill in those missing pieces. In terms of bailment for reward, such as in rental situations, the bailment for reward is one in which must be considered in terms of exchange between parties. An example is this is a rental agreement. This is the most common form of bailment. It includes such arrangements as the rental of water coolers, cars, rug cleaning equipment, computers, photocopiers, and so on. The common law standard of care is usually that by which reasonable, diligent person would take of the goods in the circumstances. Generally, this is the same standard as a reasonable person standard in tort law. Although the bailee generally is not liable for ordinary wear and tear on the rental equipment under bailment and reward, he or she has a duty to take care of the items as if they were their own, and they can be sued by the bailer if the goods are damaged. In terms of bailment for consignment, consignment is where a shop or an individual sells an item on behalf of someone. It's considered a bailment for reward. If the item is not eventually sold, it would be returned to the owner. So unless an agreement between the parties states otherwise, the standard of care is the same as those outlined above for the bailee, and they must exercise care with regards to looking after the product the same as an ordinary person would do in order to take care of the goods in that circumstance. In terms of another form of bailment for repair and services, it involves the bailer, the owner of the item, who pays someone else, the bailee, to repair the item in question. So you bring your car to the garage, for example. The bailee must make the repairs in a skillful manner under the contract of repair. And while the item is in the possession of the bailee, the common law of bailment states that generally they have a duty to preserve the value of the goods at a standard as if the repairman owned them. So this would mean that whoever's looking after the car, the garage, will have the same responsibility for the car as you would, seeing you own it. In part 3, we look at intellectual property law. And intellectual property is very much an intangible item. It is not physical. It is someone's idea, someone's design, someone's invention. It is not something that you can look at and say, this is something that we can clearly see was made by you. So intellectual property law has become critically important, particularly in the realm of the internet. So intellectual property is really a subcategory of intangible personal property referred to as ideas, information, and creative works. Intangible personal property refers to the rights or the claims that one person has that has value or can be enforced in the courts, such as the right to collect a debt. These rights are often referred to as chose in action or right to sue. So right off the bat, you're running into some challenges in the court because, again, it is personal property in the form of ideas, information, and creative works. These are often very difficult to point to and say, that is mine. Okay? So, and when you are granted that intellectual property right, the job of the court is to ensure those rights are protected. And it's a very difficult challenge for the court because it is just ideas and information. It's very hard to define who came up with it. So intellectual property law attempts to balance the protection of the product of a person's mental effort on the one side and the free flow of new and innovative ideas that stimulate the advancement of commercial environment on the other. So there's a little bit of a paradox going on. The thing is, our world develops and our whole economy develops really on people coming up with new ideas on how to do things that make us more productive. So you can imagine years ago, I'll just take something, a very tangible thing that people can relate to. Years ago, in order to put paint on a wall, in order to put paint on a wall, you used to have to use a paintbrush, and it took an extreme amount of time and energy to paint. Brushing is very, very slow. It works, and you can do it, but it takes a lot of time. A Canadian inventor came up with the idea of a roller. And this roller would have bristles on it that would hold paint, and you could roll it onto the wall. And it sped up the painting process by about a factor of 5 times. And it did a very good job. True, you still need brushes, but the paint roller brought tremendous efficiency to painting. Now, the thing is that in our society, we'd like the idea of efficiency because we can do more with less. It takes less time to paint a wall. You can paint more walls. Cost of painting the wall goes down. Human effort is reduced. A lot of positives that contribute to the overall wealth of our nation and overall wealth of our economy. So people are going to say, yeah, I want one of those. That's a good idea. Well, at the same time, if we flip around and we say, okay, let's look at the individual who came up with the idea of the paint roller. He or she would certainly want to benefit from their invention. They want to, make sure that they're rewarded for their innovation. And in order to reward them for their innovation, you got to limit the number of people who have access to that paint roller, or
make sure that those people who have access to the paint roller pay the person who came up with the idea. So it's a bit of a double-edged sword. We want it to be used and put into place because it encourages efficiencies and it makes our society more efficient and adds value. Well, at the same time, we want to ensure that the person who came up with the idea makes the most on it. So we don't want everybody using it. So we're at this kind of a seesaw between free flow of ideas and compensating innovation. So government and the law has really been wrestling with this idea for many, many years. And legislation has been developed and legal precedent has been developed around this idea of intellectual property, the ideas. So, the paint roller is really a tangible embodiment of the idea. What we're focused on is the idea. Okay, so most legislation protecting intellectual property is federal, while copyright and patent legislation being exclusively granted by the federal government. So the federal government has really taken the reins on this. If you look at the Constitution, 1867, it grants the federal government authority to do this. And this is good because, as you're well aware, the paint roller is used in every single province. So it's not as if we need different legislation in each province. So there are really three major types of, three broad categories of intellectual property out there. There's, as I say, ideas, which encompasses works of art and things like that. And there's physical products that are developed, such as paint rollers. And there's images or logos, these sorts of things, industrial design, we'll call it. So there's a lot of permutations on intellectual property. The very first one we want to deal with is the one that is probably most common, and that is the concept of specific protections for works that are written down. Copyright. The Copyright Act was first brought into place in Canada in 1928 and has been amended lots of times since then, but the fact of the matter is it has almost 100-year history in Canada. And effectively what the copyright does is specifically protects computer software and also protects original works published on the internet. It extends to the authors of written work or artists in the case of something that is drawn or whatever. It extends protection from the end of the calendar year in which they die for 50 years past that date. So essentially, what copyright does is it makes sure that the author of a work continues to own the rights to that work for up to 50 years after their death. So their estate will really benefit from it. So if you're someone like Drake and you pen a song, that song is protected by copyright. And it will remain protected by copyright until 50 years after the death of Drake. There's no formal registration necessary with copyright. The moment you write something, if you are listening to me now and scribbling on a pad of paper, and that scribble that you have there, that is automatically copyright, meaning it is yours and it is protected as yours for 50 years past the period of your death. There's no need to register it. Now, the question then becomes, well, if I don't register it, who's going to know that I did it? And that is the fundamental problem, isn't it? It's one thing to say that there's no need to register it, but how can you prove it's yours? So you can register a copyright, but you don't have to. But the fact of the matter is, fundamentally with copyright, it is your job to protect your copywritten materials. It's not the government's job. So that scribble that you wrote down, if I took it and copied it and sold it for money, you would have to come after me to stop me from doing that. The government wouldn't be the ones to come after you. So really, copyright is for the beholder of the copyright to ensure that the copyright is kept. So the owner of the copyright controls the reproduction of the work during the period after which the work becomes part of what we call public domain. You'll notice that in church, a lot of the hymns are very, very, very old. And the reason they're very, very old is because they are all in the public domain. They're outside of the 50-year period of the fact of the author's death. And this kind of saves the copyright issue in terms of churches or performances. And this is the thing, you say, well, I can sing a song by Bob Dylan. Bob is very much alive. Am I breaking copyright? In the strict sense, if you're making money on it, you are. It is his song. You're making money on it. You're making money off his work. So theoretically, he should be entitled to a certain portion of your work. Now, the question is Bob Dylan going to come after me for that? Probably not. Now, if I introduced a song and it became wildly popular and I made a lot of money on it, Bob Dylan will probably be after me on it. And Bob would do one of two things. He could either cease and desist, which would stop me from doing it, so the song gets erased, more or less, or he would collect royalties from it, which is the more likely case. The Copyright Act gives the owner of the copyright a monopoly. So effectively, it is a monopoly over the use of the created work, prohibiting copying or reproduction of the work without permission. And only the actual work itself is protected, not the ideas behind the work. So what's covered? There's a lot covered under here. There's literary works, which are literary compilations, such as articles and postings, news feeds, books, computer software, code, and hardware design. Dramatic works, movies, videos, television, theater productions, performances, including choreography and scenery that's fixed in some permanent form, such as writing, including electronic. Musical works, musical compositions with or without words, including music embedded in a website or stored electronically. Artistic works, paintings, drawings, charts, maps, plans, photographs, sculptures, graphic user interfaces, and architecture. In addition to these works, copyright protection has also been extended to performances such as actors, musicians, dancers, singers. Sound recordings such as CDs, tapes, computer memory, and methods for reproducing sounds. And communication signals such as radio, television, cable, and internet broadcasts. All of those are protected by copyright. So it's interesting to see how many things are covered by copyright. Now, as I say to you, that he who owns the copyright's job it is to maintain the copyright. So copyright belongs to the person who created the work or to the employer where the work was created as part of employment, unless there's an agreement otherwise. Now, this is an interesting one. In a lot of places, such as the college or the university or something like that, you look at these courses, for example. The copyright. Who owns the copyright on this class, for example? Okay, so this class is recorded. Who owns the copyright for it? Well, in some organizations, that copyright goes to the individual. In other organizations, it goes to the organization. In the case of the college, in our contract of employment, it clearly says that the college owns the copyright to the classes. In the university's case, the university, the professor owns the copyright. So this provides some interesting problems or challenges for organizations who may have people who are inventive by nature, okay? So let's assume that there was an art class going on by the college, and the artist at the college produces a work of art that's worth millions of dollars. Who gets the money for it? And that the advantage for the institution is that it could be a great source of revenue. However, the disadvantage for the individual is, it's their work, and the college got the benefit because they happen to work there. So all of these are presenting some interesting cases and problems for who owns the rights to the products that you produce at work. So one of the things that your contract of employment should state is, if you're in an inventive type environment, you need to be aware or wary of who gets the copyright for the items that you produce. So once copyright has been created, its owner can assign or license it, all or in part, to someone else, including to a corporation. So oftentimes, like if you look at a lot of the music that's being produced today, what the artist will tend to do would be to move the copyright to a corporation. And the reason of that is that a corporation has an indefinite life, as we've seen, right? So this 50-year rule after the death wouldn't hold. So if the copyright is owned by the corporation, the copyright will be maintained literally forever, or until the organization disappears. The owner of the copyright can assign it to someone else, but even then, the author will continue to have moral rights to the work. So you can sell your copyright, but you still have what's called moral rights. And when we think about moral rights, there are really three moral rights: attribution, integrity, and association. And this allows an artist, author, or performer to demand that, one, her name or pseudonym continue to be associated with the work as the author; the work not be distorted, mutilated, or otherwise changed in such a way to degrade it or bring harm to the reputation; or three, the work not be associated with any products, causes, services, or institutions in a way that may be prejudicial to the author's reputation. Now, where has this happened? Well, if you go back to the Trump campaign and other political campaigns, you will find that several artists have complained. For example, Neil Young, a Canadian artist who lives in the United States, very well known. Some of Neil Young's songs have been used in political advertising, or political rallies, we'll call it, political rallies, by the Trump organization. And Neil Young has gone to that and asked them to stop using his songs in their political functions. And the reason is that he holds moral rights as well as copyright rights, moral rights to those songs, and that he can, under law, he can ask that they not play those songs. Again, it's his job to manage it, though. So copyright can be assigned but moral rights are retained after the assignment. The moral right of association bars the use of work with a product, service, cause, or institution that is prejudicial to the reputation of the author or without the author's permission. So political parties, be warned. Here's an example of Sarah McLachlan, for example, a Canadian artist again. Sarah McLachlan's song, "I Will Remember You," was used in a video that related to the Columbine High School tragedy. And a police force had used it to make a video for some reason or another. And what had happened is that she found out about it, and the video was being sold for $25 each. And she found out about it, and she asked that her song not be associated or not be on that video. So the tape was put together for firefighters training. So the decision to sell the tape followed a court order to make it available to families of victims. Now, okay, so copyright is restrictive. We know that. Okay, and what, from a user's point of view, if you wrote something or had a famous piece of artwork or something or another, people like to enjoy it. And sometimes people like to use it for study purposes and the like. And the question is, what does copyright do to prevent you from doing that? Or what can you do with a copyright item? So amendments to the Copyright Act broaden the fair dealing exception, expanding on the right to use copyrighted work under certain conditions. So the general public can use copyrighted work under certain conditions. Education, satire, and parody are allowable fair dealing circumstances such set out in the Copyright Act, as well as research, private study, news reporting, criticism, and review. So you can use copyright work, so for example, a quote from a book or whatever, for the purposes of education, satire, parody, and the like. There's no infringement on copyright if the copyrighted work is used for any of these purposes, provided the use also meets the fairness factors established by the court that take into account the purpose, the nature, the amount, the alternatives, and the effect of dealing with the work. In terms of infringement of copyright, infringing copyright includes situations where a person tries to obtain the benefit from the sale, reproduction, distribution, performance, broadcast, or other commercial use of a work. So again, there has to be a benefit going to that person who's using it. Plagiarism, copying another's work and claiming it as your own, is also a violation of copyright. The moral rights of an author are infringed when someone else asserts authorship or the work is mutilated or modified in such a way that the reputation of the author is harmed. And this is a big challenge for a lot of authors or a lot of people who design things. I'll call it artistic works. Okay? Let's assume that you take a picture of an artistic work, the Mona Lisa, say, for example, and you stretch it. You put it on and you stretch it in order to fit the page. In other words, you mutilate it. That would create some very serious problems for the author. I don't know if Leonardo da Vinci is the author. I don't know he'll be too quick to come and sue you on it. But the fact of the matter is, you want to preserve the shape and don't mutilate the work. Regardless of who owns the copyright, where moral rights have been infringed, the author can seek an injunction or compensation. Again, so this moral rights issue comes up. So that's copyright. That's the very first one that we're dealing with. Any question on copyright?
No.
Okay, so the key thing that you want to take from copyright is copyright benefits the author, but it has to strike that balance between benefiting the author and making sure people can use it for their purposes of whatever, being able to read the work, being able to enjoy the work, being able to criticize the work, being able to report on the work, these sorts of things. Another very important component for intellectual property legislation is something called patent legislation. So patents are really a design, it is a protection of a design. Okay, so I have a stapler here in front of me, and if I look at that stapler has a mechanism, and I can push down on it and pushes the little staple out, and the staple binds the papers together. Now that is a patentable object. In other words, it has some form and function. And patentable items tend to have a form and function that is really the essence of what the patent is covering. So the Patent Act, the Trademarks Act, and the Integrated Circuitry Topography Act are all part of this patent type umbrella. and it gives the rights to the inventor. The inventor has some degree of control over the product. just this past year, Arctic Cat, which is an American manufacturer of snowmobiles. Anyway, Arctic Cat used a design for their snowmobiles that was patented by Bombardier. And in fact, Bombardier took them to court. And they were awarded $3 million in damages over the patent infringement. But you think, well, $3 million is not a lot of money when you're talking to these huge corporations. But one of the other things that was in the patent infringement case, or the award, was that Arctic Cat was no longer allowed to sell those snowmobiles in Canada. And this obviously had big implications for them. And in November, they reached an agreement. So Arctic Cat snowmobiles were again available for sale in Canada, but it certainly did the job on Arctic Cat for a few months anyway. And it created some serious challenges over this. So every once in a while, you see examples of this type of situation happening out there in the marketplace. Okay, the next thing that we looked at that also falls under patents is something called a trademark. Now, a trademark is really a symbol. It's a symbol or a design. The symbol has a design to it, or a sound. So, for example, when you go to Netflix, and that sound that Netflix makes, that's patented. The NBC chimes, that's patented. Or a color. Certain colors are patented. McDonald's, the yellow, patented. So what we got is really some distinctive feature or combination of distinctive features that sets it apart. Okay, so it can be a word, a design, a symbol, or packaging. So the trademark identifies the source of the manufacturer of the goods rather than the product itself. Okay, it's very much a trademark is like the Nike swoosh identifies Nike, the corporation, as opposed to the type of shoe. And once they're registered, they're protected by the Trademarks Act. And that prevents people from taking the trademark and allows you to guard your trademark. Because realistically, companies, you know, we talk about in accounting, you talk about goodwill. Now, goodwill is a major asset for companies because what it does is it's really their brand name. Tim Hortons, they have a lot of goodwill tied up in the brand name. So they're going to do everything they can to protect the brand name. And the trademark really embodies that brand name. So applying for a trademark registration is a complicated process requiring services of an expert, and once registered, trademark must be used. Failure to do so could result in the loss of the trademark through abandonment. Also, whether the trademark, whenever the trademark appears, it should be marked with a R symbol. You see that little registered trademark, that's what that means. Or you can put a TM there if it's not yet registered. So trademarks can lose their status, and this is a big concern for businesses. And again, it's one of these double-edged swords, okay? Aspirin, trampoline, Kleenex, linoleum have all lost their trademarks because they came into common use. But you know you've made it as a product when you become a verb. You Google, right? Google has become a verb. Or you go on skidooing. You go skidooing. It's become a verb. And, you know, companies relish that in one breath because, wow, they're so known in the industry that they are the top. And that's top of mind. Everybody is always saying your name. The challenge with it is once people start doing that, then your trademark comes into question and your logo and your brand could be compromised by the fact that everybody calls a snowmobile a skidoo, or everybody calls a search engine a Google. So, you know, and we've got this situation happening right at this instant. So here's a story that was in the news yesterday and today, and will be there for a little bit. It's kind of a neat little story. This company, Satan's Shoes, this company have gone out, MSCHF Product Studios, whatever they're called is the name of the company, but they've gone out and they've created Satan's Shoes. So what they've done is they've gone out and got a bunch of Nike sneakers. I don't know what type of sneaker it is. They've gone out, they picked out these sneakers, And they added one thing to them. They put a drop of blood in a little bubble in the shoe and attached to the shoe, and they sold them. In fact, they sold 666 pairs yesterday, and they were sold out in a matter of minutes. Anyway, they're devil-themed shoes is what they're called. And Nike is in the process of suing them now for trademark infringement. And you can read that story. That story. You could read that story if you click on that link there. So athletic shoemaker Nike on Monday sued New York-based company that produced Satan shoes purported to contain a drop of human blood as part of a collaboration with Old Town Road rapper Lil Nas X. I don't know who that is. But anyway, Nike said in the lawsuit, the company MSCHF products infringed and diluted its trademark with the black and red devil-themed shoes, which went on sale online on Monday. Lil Nas is not named as a defendant in the suit. The shoes are customized Nike Air Max 97 sneakers that contain a red ink and one drop of human blood in the sole. According to the website described, the 666 pairs of limited edition shoes, the back one shoe says MSCHF and the other says Little Nas X. Anyway, so Nike is in the process now of bringing them to court. So that's right now going on. As I say, you see this stuff happening quite a bit in the news, and it's often fodder for a lot of legal to and fro.